So accounting is my love and my specialty. And studying the law and studying trust law with Randall mentoring me is my second favorite thing to do.
Well, you've been excellent at it, and you have some 25 clients, I believe, of BIC who have, you've assisted with nominee settler or trustee services, and everybody seems to be happy.
Yes. So if someone is in the seminar and they're contemplating putting a trust together, the nominee settler position is where you can literally nominate someone to help with anonymity of your trust. And I have done that for a number of clients. And then if in someone putting together their trust, they do not have someone to hold an adverse position, I've been helping people as a co-trustee.
So everyone, we're waiting for Randall to show. This is his bio. We generally introduce him as the head of the trust department at Brilliance of Commerce and founder of House of Freedom Trusts, trustee of White Light Unlimited, One People's Public Trust, and creator of the International Natural Law Trust. And then we have today the elements of a valid private trust as today's topic. Dominique, I'm going to go ahead with the next slide and let you just improvise on that. This is the slide that Randall wanted with intent through settlers' words or conduct. So for a trust to be valid, it has to have expression of trust intent, precatory expression of interest, and sufficient intent. So I know we're asking you a lot to ask you to wing it until he shows up, but if you can, would you be able to comment on those things?
Absolutely. So the foundation of a trust is that a trust is a contract. We have the right to contract. So what is explicit in everyone's use of trusts throughout hundreds of years that they've been used is that the trust indenture is expressing the intention of the settler to create a contract where the trustee is going to be in charge of assets for the benefit of the settlers named beneficiaries. And this intention has to be clearly written down in our private irrevocable trust in order to make the trust administration flow smoothly and in order for the trust to abide by some basic laws that trusts have followed for quite a number of hundreds of years now and is documented basically in court cases. So if you look at Black Law's dictionary and you look up trusts, there are about 90 different trusts included in that definition. And the trust that Randall has put together, the trust indenture, is very, very specific and written in English so that it is more easily understood of exactly what the intention of the settler is.
You mean in plain high school English?
Yes. Much appreciated.
Not advanced legalese.
No. You do not need a Black Law's dictionary in order to administer your trust. Okay, you're going to laugh, but Tanzan, can you speak to B? And then I could speak to C.
Well, precatory simply means based on having set an intention. So as a preliminary qualification, the word precatory basically means that it's set up according to the plan or the intention, the desire, the purpose, right? And so the expression of interest has to be there in the beginning. Well, what is this trust being set up for? What's the purpose? Why? You know? And it started, centuries ago, as Randall explained in some of his webinars, where back in old England when a lord of a manor had to go off to war or something and he wanted to protect his land and his house and all that, he would turn over the control of it to a friend and entrust that to his friend while he was away. And if anything should happen to him that he doesn't come back, then the beneficiaries, meaning his family and his heirs, would, the asset would be passed on to them. So that friend would serve, as it were, as a trustee. So that's an example of a precatory expression of interest. Would you like to elaborate on that?
That's awesome. And I think part of that is when we're putting together our trust, that we have a clear understanding of the role of a settlor, a trustee, and the beneficiaries. And my understanding is the way that Randall has his trust set up, we use units of beneficial interest, and 100% of those units are designated to beneficiaries. So it's very clear what the intention of the settlor is. And I think that speaks to the sufficient intent, is that by having a very clear contract, that's how we keep out of the ending up in courts. It's how we stay out of ending up statutory. We have our contract, our trust indenture is so clear with the intention. It's so much easier to administer, and there are less legal problems.
All right, should we go to the next one?
Sounds good.
I do have a text from Randall saying, "What's the code?" So I'm about to text that to him.
Excellent.
We'll let you carry on for the moment here.
Excellent, and we can back up, and he can catch the things that we haven't shared.
Yeah.
So trust property. So you have the interest in the property, equitable interest, and alienability. So what happens with a trust, and basically this happens with all trusts, it takes an asset and it separates the asset into two things. The first is equitable interest. That's like the ownership title of the property or the asset. And the second thing is beneficial use. And by separating a piece of property or an asset into these two things, we are able to actually better protect our assets. So the trust property that's held in the trust, the trustee signs for the property and then puts comma after their name, trustee. So they're signing for the trust as the trustee. So they don't own it as a person, but the trust owns it, and the trustee is signing in honor of the trust as the trustee. It's very clear on every document.
That's an important legal distinction.
Correct. So that is the equitable title. And then the beneficial interest is what is enjoyed by the beneficiaries. Were you successful with Randall?
I got the code sent to him, and let's see. I haven't seen him yet, but hopefully soon.
Excellent. Randall uses or brings to our education many excellent words and terms that I haven't necessarily studied just yet. So I'm not quite sure the magic that he's going to explain with alienability, but I do know this, that part of the beauty of the trust is, say you have a trust all set up, it has a piece of property and a business in it, and that trust is caring for your children. Say something happens, unfortunately, to one of the children where they get sued. Well, the trust has the ability, the trustees have the ability in this trust indenture to withhold beneficial interests or even beneficial monies if for that child it actually makes it better in their case. There's less that they can be sued for. They don't own anything, and you can't sue for a beneficial interest. So in this way, I'm visualizing you could alienate them for a short period while they work through their legal case, and then when their legal case is resolved, their beneficial interest can be resumed by the trustees. So that is a really nice feature about controlling beneficial use by the trustees. They can actually benefit the beneficiary through different ways that they're experiencing their beneficial use.
Do you want to comment on own nothing and control everything?
That's a beautiful mantra. Own nothing and control everything. So in our trusts, if you choose to have a nominee settler, then you could wear two of the three hats. And in that sense, you could be a trustee and you could also be one of the beneficiaries. And in that sense, you are helping to control what's happening with the assets with other co-trustees, because at that point, you should also have a co-trustee who is adverse. And by participating and working together, you can guide so that those assets are increasing in their cash flow. And then as a beneficiary, you can be enjoying the use of a piece of property, but you could never be sued for it because you don't own it. So it's a very strong position. Rather than ownership, we don't want to own, but we would like to participate in the control.
Okay. We have the settler. Can you see the slide?
Yes, settler with capacity.
Mm-hmm.
So there is capacity, there's rights in trust property, and there's the settler's creditors. So I'd love to, so capacity normally means what you are able to do. And technically speaking, in the private irrevocable trust that Randall has written, the settler irrevocably puts an asset into the trust. And by doing that, the settler literally signs a document at the end of the trust indenture saying, I have let go, and separates, the settler separates himself from the asset. And what that does is it protects it. So now later on in life, if the settler had a creditor who said, hey, for whatever reason, I'm suing you for this, this, and this, the assets that were properly placed in a trust are no longer his. So they're not available to any of the settler's creditors in the future for resolving some issue in the future. They are now protected. Those assets are protected. And the trust property, rights in trust property, that is held, that there are basically two bodies of law that help to govern what happens with trust. One is the law of contracts, and the other is the right of property. And it is strongly held up in courts, irrefutably, that trust property is protected in a trust. And what's really going to be fun is when we get Rand on the line, he's going to have magical comments that will enlighten us on many other things that we don't know about because of his particular choice of words here. It's very interesting.
Well, I like your choice of words, magical.
Well, what I've really enjoyed, I've worked with a lot of contracts in 30 years. I worked with contracts that were hundreds of pages, and I've needed 2 lawyers in order to understand how to function under the contract. And the nice thing is, Randall has worked for so many decades in this industry. He really has helped to resolve down exactly what we want to do in our trust and also advise us what we don't want to do. So when people work with Randall, he gives good suggestions so that when your trust is set up, you're clear about certain things that you should do and some suggestions about something perhaps you shouldn't do. So he's very, very helpful to us as his clients.
In the fields of science and education, it's known that one of the greatest talents is to be able to take something that only, multiple PhDs can understand and convey the same knowledge in layman's terms.
Exactly.
That's rare, and that's what Randall's been able to do.
And I have a favorite quote when we do our trustee study groups, where I keep reminding people, we may study something that's complex, but we know that we have gained elegance and grace when we have distilled it down to simplicity. And maybe
Yes.
even decided we don't need that complexity. That's even better.
Right. It just confuses things.
Exactly.
And that's done intentionally in many fields of law.
Unfortunately, the creation of gray areas, it has been done many times through legislation. But the goal with this trust indenture is that all of our laws in the United States are based on common law, which was the unwritten law. And then the statutory law is what our legislatures vote on and approve. And so the idea is that we're always supposed to be in harmony with common law. And I like to think of common law as what makes sense to the common man. So this trust indenture is using language of what makes sense.
Right. I still don't see Randall, so you still have the floor.
Ah.
Okay, let's proceed. We have this one is about the trustee.
So trustee, why do we need a trustee? Capacity to take and hold title, capacity to administer, and co-trustees. So if you just had a settler, the person who has an asset, also called the grantor, and a beneficiary, so if you only had those two people, you have what we all currently have. We have our person, and our person wants to give to another person. So that's what we currently have. By making a contract and bringing into it the title of a trustee, someone who we place our trust in, we are creating a situation that we cannot create on our own. So the position of the trustee is able to take equitable title of an asset. And the only way that we can do that is through creating an entity, through creating a contract to make that happen. Otherwise, the trustee doesn't exist. The trustee is created by our trust indenture and the intention that we put into our trust. We create that trustee position, and we literally appoint our first trustee. So the nice thing is you can have multiple trustees, and that's really nice. It's like having a corporation and you have multiple people on your board so that you can make good decisions and have advisors. So you may, in your trust, you may have someone who's excellent with business and assets and getting a cash flow going. And then you may have a co-trustee who knows the beneficiaries and who understands how best to care for the beneficiaries. Because it's not always money that a beneficiary needs. They may need a recommendation for a good college to attend, or they may need mentorship. Tanzan, there are a few questions, I think, in the chat box.
Yeah, you know, I was thinking normally everyone, we wait until the question and answer section of the webinar to entertain them. However, since we're waiting for Randall, Dominique, if you wish, you're welcome to take, since this one question has to do with the trustee topic that you're on right now.
Yes, there's an excellent question about an adverse trustee and what is an adverse trustee. So you won't see written in your trust indenture the word adverse. What we are describing is the kind of person that the person is who is your trustee or co-trustee. So adverse legally, it's applied to trustees in that that person is not related to the settler by blood, marriage, or employment. And what that means is that person can't be manipulated in the decisions that they make. So it's very important that this be clear in the way that your trust is set up, because if you don't have an adverse trustee and the trustee is under the control of the settler, then there is a possibility that something could be undone in your trust if the settler is also my computer tells us the time, if the settler is also beneficiary. So that adverse position is in order to make your trust administration very clear and clean, because the decisions made regarding the assets, they have to be made in the best interest of the beneficiaries. The settlor who, unlike a trust that's created at death, the settlor is still alive. So the settlor is able to comment to the trustees about how's it going, and they can offer some ideas and suggestions, but they don't control the trustees. And so by having an adverse trustee, someone who's not related by blood, marriage, or employment, that person can make up their own mind as to whether the action contemplated is in the best interest of caring for the assets and caring for the beneficiaries.
Meaning that if the trustee were too closely related and the trusts were challenged, the court could potentially say that that person is just your alter ego, and it's not really, there's no separation, and therefore it's just still the settler controlling everything, which is considered a sham in the trust community. It's called a grantor's trust, meaning the grantor still stays in control of everything. He hasn't really turned over control of things sufficiently.
Correct. And that is a vulnerable position. Randall coaches us with the private irrevocable trust how not to be vulnerable. So why do we need the trustee? We need the trustee to hold title of any assets that are inside of our trust. The trustee is also the administrator, and you can have multiple trustees so that this way both the assets and the beneficiaries are properly cared for.
There we go.
So next slide is identifiable beneficiaries. So we're going to review the necessity of having beneficiaries, the provisions for satisfying the requirement, the trustee's awareness of intended beneficiaries. So this is a very interesting slide because in our trustee study group, we've had a number of questions about the beneficiaries. And so my understanding is limited to a couple of court cases and studying the book, The Art of Passing the Buck. In there, it suggests that one of the responsibilities of the trust is that at some point, sometimes it's done at year end, the beneficiaries should be notified of what's happening inside the trust. Some basic, not lots of detail, but some basic summary reports so that they know that the trustees are doing their job of properly caring for the assets. And they could, ask some questions and interact. And the idea in The Art of Passing the Buck is that what we want to do is create, they call it a family trust. So whether it's a family that's blood or whether it's a family of friends that you have adopted, we want to create a family of trusted people where we are creating an ability to use wealth wisely and ensure that the wealth passes on from one generation to the next. And the most important wealth that we all possess is actually human capital. So that is our knowledge of how to go about the art of living, the art of business, the art of creating cash flow, the art of sharing resources, and doing things in a socially responsible way. So that necessitates that there is a relationship that becomes formed between the trustees and the beneficiaries. Inside the trust indenture, there are very specific sections that spell out how the trustees are to care for the beneficiaries. So it's not left up to your imagination. There's very specific instructions, and the grantor can also write some letter or some notes that can be incorporated as trust minutes that also speak towards how the settlor was intending for various beneficiaries to be cared for. Like, for example, if you have a younger child, there may be an intention that the child either be encouraged to go to college or to attend a trade school, and that there be monies made available to make this happen. So there's the basic powers of the trustee to care for the beneficiary are very well written out. And then also the settlor can make comments about what more they would like done with beneficiaries, writing down a note, and that can be incorporated into trust minutes. And the trustee has to gain a knowledge from the settlor of what is their intention for their beneficiary. Is there something that they need to know? Perhaps unfortunately, sometimes we have beneficiaries who are experiencing business troubles or personal troubles or even medical troubles. And we need to know as the trustee, hey, settlor, what's your intention of how this beneficiary's needs should be met? How would you like us to work with them? So it is, think of it as creating, for me, I think of it as creating a family environment.
All right.
Do you have some more to offer too, Townsend?
No, you're doing great, and you're getting compliments from the audience. So.
I do see a note about how to join our study group. If you have a trust indenture from Randall, just go into Brilliance and Commerce and put in a support ticket, and just send a note to Peter and Townsend, say, please give me the link to the study group, and you'll get passed on to us. So that's how we do it.
Well, actually, it's supposed to be automatic. If you're a trust client, if you've paid and purchased even an unactivated trust from Brilliance and Commerce, then that is supposed to automatically put you on the newsletter list for the trust study groups that Dominique conducts. But if you're not receiving those, then let us know. Yeah.
Perfect. So valid trust purpose must be used for honest legal purposes. So this is incredibly important. If you have an illegal intention, this private irrevocable trust will not work for you. This trust, it will only protect legal, lawful efforts. That is the only way that it works. So if there is anything that is illegal, you will immediately be thrown into the statutory world, and you will have to respond to subpoenas or respond to search warrants. And yeah, so everything about this private irrevocable trust is based on integrity. It's based on ethics, clear morals about wanting to help people and wanting, basically, you're promising as a trustee, you're promising to be a servant in kindness to the beneficiaries, and you're working off of the intention clearly stated by the settlor. So someone said Skype is breaking up a little bit. Sorry about that. I'm plugged in, but we are working through different states, and our wonderful Randall is working from Hawaii, so he may even be having a connectivity.
It's not breaking up, I don't think, for the rest of us.
Good. Excellent.
Yeah,
excellent.
And we're hardwired. Plus, it's not Skype, it's Zoom, but anyway.
Oh, excellent.
So we have a message here from Randall, everyone. He says, I'm not fit for the show today. Sorry, I'm pretty distraught. Was ready earlier this AM, and something triggered something. So for those who don't know, Randall lost his wife. What was it, in October?
Yes.
And he's been having a hard time getting over that. She passed on to the other dimension.
Yeah.
So please send your blessings and love to Randall. He's not feeling well, so I guess it's yours, Dominique.
Our hearts go out to Randall, and he will enlighten us further on all the things that I have missed.
Yes.
We'll have a beautiful conversation with him, but our hearts, prayers, and best wishes go to him.
Yes, it's good practice for you.
Next slide.
Okay. Well, we're into questions now, so we can go ahead and do questions.
Awesome. So if I'm not, let's see, I'm going to...
as you can tell, Randall, as you were saying, he kind of elaborates a bit more on each of those and unpacks them, you know. But the Q&A can give you that opportunity to do as well. And that way we know what everyone is wondering about, you know.
Exactly. And the interesting thing is he called this the ascending trust knowledge, if I'm not mistaken. And I really like that because part of the purpose is to realize when we get involved in our trust, most of us may not know anything about having a trust. We may have never dealt with someone who's died and then had assets to pass on to other people. So we don't understand the need for any of this. And so in beginning with the trust, our knowledge is ascending. And if you enjoy reading books, I've really enjoyed The Art of Passing the Buck, Volume 1, because in there it suggests it may take a year or two before you're really comfortable driving this beautiful vehicle called a private irrevocable trust. And that is totally okay. And that's part of why we do a joint study class together, because we are all enjoying this journey of learning together and trying to weed our way through what we want to do and keeping it as simple as possible, but also realizing trust administration requires paperwork. You are going to learn to produce different documents, which you will print and sign, put into a binder, and that binder is your trust entity with those signed documents and your intentions in writing. So we do this together. And the nice thing about thinking about that, you don't have to feel overwhelmed. If you jump in and your intuition is saying, this is a good thing, I need to get involved with this, I encourage you wholeheartedly that there is lots of support and that you will be able to understand how to lay the foundation for your trust with Randall's help and also administer it. So I want to encourage everyone, if you have not purchased a trust yet and you're considering it, please do so. Let's see.
So for those who don't know, if you're on the telephone and you want to raise your hand to ask a question, press *9. And if you're watching via a smartphone or computer, then you have two ways. You can either click on the raise hand icon, excuse me, or you can type it into chat.
So there's a wonderful question regarding own nothing and control everything. If it is your property originally, how are you not the grantor of the trust? And do you change ownership of the property so as to avoid liability? So this is an interesting question. I'm going to unpackage it a little bit. So first, say that you are the settler of your trust. When you create your trust, there is a schedule that you can list your piece of property on that you want to put into your trust, and you will literally exchange it into your trust. And by doing an exchange, that is not a taxable event. What is taxable is when you sell something, or what's possibly taxable is when something is sold, or also possibly when something is gifted. So in Randall's trust indenture, he gives very clear instructions about how property is exchanged into a trust. And what that does is it makes the trust a pass-through. The accounting term is called a pass-through entity. So our goal is that if there is a possible tax event, that would happen either before an asset goes into a trust, or it would happen as the beneficiaries are receiving benefit, there may be a tax event to the beneficiary. But inside of the trust, we exchange assets into the trust such that the private irrevocable trust is a pass-through entity. And if you have more questions very specifically about that, when you're working with Randall, he's really good at answering emails and addressing your specific concerns. And yes, the ownership of the property will change. Once you put it into the trust, you will then be doing a quick deed, depending upon where you're at or what country you're in. In California, in the United States, we can do a quick deed and change the title of the trust, change the title of the property into the name of the trust. Good question. Excellent question.
One question that came in to me the other day that might be of interest to others is, it came from Australia, and it was regarding the superannuation, which is their form of an IRA or KEO retirement pension. How can they make that work with the natural law trusts? And of course, I talked about the trust being the beneficiary of it, because most retirement pensions will not allow the trust to be the owner, but it can be the beneficiary. Do you want to comment on that?
Yes. So anytime that somebody, when I say someone, somebody wants to tax you, then that situation can't be owned by the trust, but the trust can be the beneficiary such that a taxing has occurred either before or after. So that's why trusts can be beneficiaries. And just real quick, Tanzan, there is an additional question. So who actually owns the property in the trust? So when you put an asset into a trust, the asset has now been broken up into two things. It's equitable title, so that's the name of who owns it, and beneficial use. So now that asset, so say it's a house, that house will now have John Doe Trust as the name on the deed. And the person who signed it could be Jane Doe Trustee, but the person who's enjoying the use could be the son, Eve, and Evan and sister Eve could be enjoying the beneficial use. They could be the beneficiaries of it. So yes, indeed, the property will take on the name of the trust, and that document is signed by the trustee. They put their formal name, comma, trustee. Any other questions? And let me know if that doesn't clarify your question as well.
And another question that often comes is, I have an LLC or I have a corporation, and should I continue doing business with that and add the trust to it, or should I just let go of that statutory entity and just do business directly from the trust? And there are pros and cons either way.
Yes, and so it's nice to write down the pros and cons. And when you're working with Randall, he does weigh in on what he thinks simplicity will be best for you. It sort of depends upon whether inside your LLC, what kind of work that you're doing. So if you're doing the kind of work that is just service over an internet, and there's not much materials, I imagine something, you're providing an online product. That may be something simple that you can run through the trust. But if you're running an LLC and it's a construction company, it may be easier to manage your business as an LLC, and there are different legal reasons for doing that as well. So for me, for quite a while, my LLC, well, actually I have two LLCs, my trust is a member of my LLCs. Tanzan, I'll let you, I can't control the asking. There's someone I think who has their hand up.
Oh, okay. JB, you are unmuted if you wanted to ask your question verbally.
Oh, hi.
Hi.
Dominica, firstly, I want to say that this is outstanding. Hi, Tamsin, and nice to talk to you again. I'm sorry about Randall, really sorry.
Yeah.
Um, really, I just, like to see him recover. But apart from all this, uh, I heard, and you guys might not know about it, but I read some time ago where under an economic emergency, which is where we're headed, that the banks can take your trust and its contents. And if that's true, upon research, how can we protect against it? That's one. Because I said, I thought that was absolutely, nobody can touch the trust. Under an economic emergency, they can collapse everything or take everything. I'm not sure that's true, but if true, then how can we protect against it? That's one question.
Do you want to take first shot, Townsend?
It is, in my humble opinion, not going to happen. Yes, there are all kinds of things that could happen. The sky could fall. I've seen those things too, JB. There are lots of fear speculations out there, and some bad things are going on around the world. But on any mass collective scale, um, if everyone doesn't mind, I'd like to make a personal prediction. Mark my word, it's not going to happen on any big, widespread collective level. Um, and I've written in my recent newsletter about that people who are saying the banking system is going to collapse in order for the new, no, it's not going to fall apart overnight. It's just not going to happen that way. Is a gradual process in which the higher ways of exchanging money worldwide are replacing the old ways. The asset-based monetary system is replacing the debt-based monetary system. And it's a gradual process that is speeding up, but there's not going to be any widespread crash, confiscation, and that sort of thing. Furthermore, I would expect that any kind of edict that has gone out saying that there could be asset forfeiture like that would apply only to statutory entities because they have no jurisdiction over these kinds of natural law trusts. That's one of the reasons we design it the way we do, is that it is not subject to the governmental jurisdiction of any authority anywhere in the world.
But if
Dominique?
it, oh, can I interject here first,
Mm-hmm.
Tanzan, on what you said? But if it's in a statutory commercial court, then don't they have authority as custodians over your trust?
No, that's one of the reasons we've been saying that not only have our trusts not been invalidated, but they cannot be invalidated. Now, certain transactions perhaps can come under the jurisdiction of a court, but not
Mm-hmm.
the integrity of the trust itself.
Okay, and okay. Well, I'll come up with the other follow up. But okay, Dominique, go ahead.
Thanks. No, I appreciate your question. And my background, I was once a stockbroker with A.G. Edwards and an insurance agent in California. And I stopped being a stockbroker and insurance agent because I felt that the ethics of what was happening, putting everyone's retirement money, forcing everyone to put their retirement monies into the stock market didn't make sense to me. So I have a lot of experience with statutory. What we are encouraged is to understand the private irrevocable trust is based on the law to contract. So that law to contract is
Right. Okay.
protected by the Constitution. So my guess is if someone were to try to come after us, they would also be trying to go after the Gettys, the Carnegies, the Kennedys, and I don't think that's going to happen. So I'm in agreement. I do not see that portent happening.
Well, they had that, that situation in Greece where they just shut down everybody's bank accounts, and many of those wealthy, it was very wealthy, that lost quite a bit of their money, and their trust set up in those banks. So, and also Lagarde just announced in the IMF that we're headed for a depression. She announced it at Davos. So a serious depression. So I just didn't know, in preparation of that transition, as you so state, Tanzan, how we can guard against this if we were headed where we're putting our assets in protection. Like you said, it probably pertains exclusively to statutory trusts. So that's helpful.
Yeah. So, I mean, everyone has to, so the bottom line rule is, with assets, you should diversify. That makes sense. So what does diversify mean? It means try to have some property, try to have some cash, try to have some gold. You have different kinds of assets.
Don't put all your eggs in one basket.
Exactly. And
but the basket is the trust. It's all in one trust, right? Or you're saying make multiple trusts in multiple banks?
No, there's a confusion here. When I say have multiple assets, it is okay for the basket to be the trust. We're saying have multiple assets. So for example, in my trust, I have an envelope of cash that my trust owns. And that's why. I also have a small bank account, and that's why.
And the more assets you have, the more trusts you should have.
Exactly.
Okay, you can have, and sub-trusts wouldn't be as good as individual separate trusts?
So that's something that you'll have to think out, because it's in regards to how you're managing your assets. So if you decide to have multiple trusts, the choice is whether they are all totally separate from each other, which means you have to have lots of separate people managing those that aren't related. Or if you have a management trust and then the assets are held separately in a layer of baby trusts. And that's something that is really good to think out on a piece of paper and then ask Randall questions about what his thoughts are.
Okay. Apart from that, if you set up a trust management company or work with one, how does that fit into the assets that you put into a trust, into this natural law trust? Do you turn over the trust or parts of the assets to them? How do they get wind of your trust? How do they work with your trust? What do they do with it if you have all the assets tied up in it?
So if
that
you're
they need,
go ahead.
That they need. Let's say they need.
Yeah. So if you're the trustee of your trust and you decide that you want to work with a trust management company, because maybe you have lots of property and lots of different assets and you're like, wow, paperwork's overwhelming, I need an assist. So the people who help you, they can either work with you via contract, such that it's like you can rent a secretary or rent a consultant, and they can prepare various documents and share ideas. And then it's your signature that would actually make something happen. That's one way to do it. The other way is you may interview someone and you say, well, I find you to be a trustworthy person, and you can decide whether they should be bonded or not. And you may decide as a trustee to appoint another co-trustee, and then you would continue to work together. But in my mind, for me, I will not be just turning over the reins, because for me personally, that doesn't work.
I just didn't know if they need to handle, let's say they're designing your projects or creating developmental plans, 400-page documents, and they want to work with your assets, your currencies or whatever. How do you funnel those currencies out of the trust to pay them? Or I just didn't know that working relationship. I thought maybe somebody did.
Yeah, sure. No,
It's 5 o'clock.
that's my computer. It works just like a normal business would work. You have a checking account, you have a project, you lay out a budget of what you're going to be working on. You make someone in charge of who's going to cut checks and what's their authority of whether they cut them and you're the one that signs them. It's similar to the accounting controls that you would put in for a business. There are very specific ways to protect the accounting of an entity that has a lot of resources. There are safeguards that you put in place so that you maintain the reins in your hands while people are actually doing work for you. So there are project management business models that are very easy to set up so that the work that you want to get done, say you have a humanitarian effort, you will be able to do it.
So you don't turn over the indenture to them, do you? Or certification minute or any of those documents that you would to a bank?
You have to decide who you're working with and the level of trust you have with them. You may decide to have them sign a non-disclosure. You get to decide. Isn't that wonderful? You get to decide how you're going to work with someone.
Okay. Imagine it's a little bit more learning curve for me to determine that. Is there such a thing as too many trustees? Can you have too many or too much of a board?
Well,
when you set up this, you construct your trust in such a way. Is there just, do they feed on each other, argue with one another, that kind of thing? Is there just, when is too much? What is the number for?
There are some really excellent books written specifically for how to render service to nonprofits as a board member. There are a lot of excellent books on how to develop teams of people and how do you get people to work together with that synergy. And so before I would recommend that you pull a team together, you may want to read a couple of books that will lay the foundation of how it is that you want to work with people and what your requirements will be for who you choose to have on your team. I wanted, yeah, excellent question.
Dominic.
Absolutely. I want to catch another question real quick. Someone said with the online business, let's see, what do I mean when I say run through the trust? So that specific question would be really good to ask in an email to Randall, only because I don't want to misguide anyone, but you do have the ability with this trust to operate in a way that you want to operate, but we keep our trust as a pass-through entity. So there is a way to run a business in your trust and maintain that accounting integrity of a pass-through entity, but it's a little more complicated than I can explain in this particular seminar. So that's it.
One simple thing you can do is title the ownership of the business to the trust. So you basically have a minute written and added into the trust saying there was a meeting of the Board of Trustees who on this date decided to transfer ownership of this business into the trust. And then the bank account is in the name of the trust, and all payments to the business are made to the name of the trust, and all expenditures on behalf of the business are made from the trust bank account. So that is how you run a business through the trust.
Perfect. Thank you.
There's more, more details than that, of course, but that's a simplified explanation. You can get more details from Randall.
So someone asked, what are the initial steps for starting a trust? And I can't, it's been so long ago, I can't remember my initial steps. Can you enlighten us, Tenson?
Well, you go to the affiliate link of the person who introduced you, or to the BIC website. You go to the trust section, you place your order. That's what starts the process. So once you've placed the order, then you receive your welcome pages, And the welcome pages give you the next procedures. You have to decide what name you want for the trust. You have to decide who you want as trustees, whether you want to be the trustee. And everyone, we are one of the only, I guess we're the only that I know of organization in the world that allows the client to be the trustee or to choose the trustee. And you can either choose the trustee from your friends, people that you trust, or have us arrange a contract with Dominique for a professional trustee service. So 3 different ways you can go for choosing trustee. And then you have to choose the other officers, such as the beneficiaries, decide who's going to be the grantor or the settler. So those decisions, the criteria for those are described in the ebook. If you haven't already done that, read the ebook, which is downloadable from the website. And there's a section in there on the roles of the beneficiary, trustee, and creator, grantor, or settler. So once you've decided those things, you fill in the trust client information form, click submit, and that begins your dialogue one-on-one privately with Randall, who will then write the trust for you, set it up, and answer all your questions about operation.
And I just want to say, you don't have to have a huge amount of assets before you begin your trust. It's actually highly recommended that you get this going while you have the time and resources to learn and read and think and evaluate how you want to do things. Once you say you've won the lottery, now you have the pressure of making a whole lot of decisions all at once. It's really nice to get this trust in place so that you now have a vehicle for you to, over the next couple of 100 years, put beautiful assets in there that will pass on down to future generations. That's how I like to think about things.
And it also serves as a kind of magnet for prosperity. It's like money sees that, oh, now you have this protected vehicle. Now it has a nice new home to come to.
Exactly. You're going to laugh, but I have a 5:30 appointment that I have to dash off to.
No problem. Well, you did a marvelous job for filling in for us today, Dominique. Thank you so much.
Thank you. Thank you, everyone.
So thank you, Dominique. We'll go ahead and conclude, everyone, and make it short today. Please send in any further questions you may have via our contact us on the website. And hopefully on February 19th, we will have Randall on. And in the meantime, anyone who wants to join the Trust Study Group, please do so with Dominique, which is in January, it was 2 weeks before today's webinar. In February, I believe it's 1 week before.
Yes.
Is it on the 12th?
Yes.
Trust Study Group webinar with Dominique is on February 12th. Those of you who have a natural law trust can attend. And everyone can join with Randall on the 19th, assuming he is able to join us. And Dominique, you're getting a lot of compliments saying you were awesome.
Our prayers to Randall. We're sending him love and light and happiness.
Prayers for Randall.
Laughter.
Yes. Yes. So I agree. You were terrific.
Thank you for the opportunity.
You're
My
clear
pleasure.
and articulate and very, very eloquent.
My pleasure. Take care, everyone.
Okay, thanks. house-of-freedom-trust.com in case you don't have a link. 360-200-7521 is our phone number. If you haven't already, signed up for our newsletter. And we will conclude with this nice saying: the moment you start acting like life is a blessing, it starts feeling like one. So everyone, thank you for your patience. Thank you for joining us today. Please stay in touch, and we will see you soon.